Right. In criminal law, you see terrible people on their best behavior. In family law, you see great people on their worst behavior. It's a quote by Laura Wasser, which I think will resonate with everyone in this room who deals with family law clients in whatever capacity. Good evening, ladies and gentlemen. For those of you who don't already know me, my name is Saika, and I head the family law department here at Branch Austin, McCormick. Welcome to our family law presentation. Thank you for coming and taking time out of your long and demanding day to be here with us this evening. I'm honored to have the opportunity to address such a distinguished audience made up of such a diverse range of professions. We're just past the first anniversary of the introduction of no-fault divorces here in England and Wales, a system that finally removed the legal requirement to blame the other person for the breakdown of the marriage. So this seemed like an opportune time to reflect on how they do things differently in Australia, where no-fault divorces have been the norm for many years. They do other things differently down under, as you're about to find out from our speakers. We have not only a distinguished audience, but a very distinguished lineup of speakers. They're all experts on how and why they do things differently in Australia. Ladies and gentlemen, I present to you, so close and yet so far, the tyranny of distance of family law issues in England and Wales and Australia. I'm now going to hand you over to Anne Bodley, the chair of the Anglo-Australasian Lawyers Society. Our speakers are all familiar with that society, all members of it, and Anne has very kindly agreed to introduce them this evening. Anne is a very worthy chair. So I can't read. And an international finance lawyer with more than 15 years experience in leading law firms and institutions in New York, Moscow, and London. She has a keen interest in international and comparative law and speaks no less than 3 languages. Anne, over to you.
This evening is definitely not about me. So thank you, Saika, for the welcome, and a special thanks to Branch Austin McCormick, with Managing Partner Hal Branch, I think, here tonight as well, for hosting this evening's International Family Law panel. As mentioned, I'm Anne Bodley, and I'm chair of the Anglo-Australasian Lawyers Society, which we know is a mouthful. And in that role, I'm delighted to introduce this evening's panel of outstanding family law practitioners. It is our speakers have done a lot of things, so this is going to take a minute. Our first speaker tonight is Julius Brookman, a family law partner at Branch Austin McCormick and an AALS committee member, whose brainchild is tonight's event. Julius brings more than 24 years of experience to his practice and an expertise in international aspects of family law matters, including 3 reported cases in the last 3 years. Julius has recently been involved in an appeal under the Domicile and Matrimonial Proceedings Act 1973, which is soon to be reported. He has also represented a footballer's former fiancée in the successful child maintenance cases of PG and TW, and has previously had financial cases before the Court of Appeal. Julius is admitted to practice in Queensland and in the UK and regularly deals with Anglo-Australian matters. Julius also has a wide circle of international connections and knew exactly who to reach out to put together tonight's panel. His outreach getting rapid acceptances from Professors Bailey Harris and Hodson, whom it is a privilege to have here tonight. So following Julius's comments on no-fault divorce, Professor Bailey Harris, going by Rebecca, I think, will speak on cohabitation issues. Professor Bailey Harris is a dual UK-Australian national who was an academic before practicing as a barrister. From 1975, she taught law and in I believe, Julius's home state of South Australia at the University of Adelaide, and then at Flinders University, where she established a new law school in 1991. From 1991, she was a part-time member of the Australian Law Reform Commission, working inter alia on the report Equity Before the Law, Justice for Women. In 1994, Professor Bailey Harris returned to the UK and was appointed Professor of Law at the University of Bristol, going on to become Dean of the Faculty of Law. She was called to the bar in 2000, and from 2005 has practiced full-time at Hare Court, where she specializes in international jurisdictional disputes. So one more bit, Professor Bailey Harris has published widely in England and Australia. She is currently an editor of the Family Law Reports, a consultant editor of International Family Law, and contributes monthly contributes monthly case comments to the journal Family Law. She has been junior counsel in many reported cases, including Miller v. Miller, McFarlane v. McFarlane in 2006 in the House of Lords, and Wyatt v. Vince in the Supreme Court. Professor Bailey Harris is a governing bencher of Inner Temple. Our third speaker tonight, and well worth the wait, as with everybody, is Professor David Hodson, going by David, OBE KC ONS, MCIArb. I don't know how you say MCIArb, but who is a co-founding partner of and now special counsel to the International Family Law Group, which is a specialist law firm representing international families. Professor Hodson is an English solicitor, mediator, arbitrator, an Australian solicitor admitted in New South Wales, and a deputy part-time family court judge at the Central Family Court, DDJ, in London and on the Western Circuit. A member of the English Law Society Family Law Committee, fellow of the International Academy of Family Lawyers, a member of Law Asia, the Family Law section of the Law Council of Australia, and holder of similar posts around the world. He was awarded an OBE for his services to international family law and appointed as QC honoris clausus, now a KC, in 2022 for his expertise in this area. Professor Hodson is a visiting professor at the University of Law and an honorary professor of law at Leicester University, editor and primary author of the International Family Law Practice, 6th edition. He will address systems and processes for family law issues. Each of our speakers will speak for about 20 minutes on their segments, following which Saika, head of the Family Law Practice at Branch at Austin McCormick, will lead the Q&A from both those online and those of you here. With over 25 years of experience in family law matters, Saika also deserves an introduction, but I think we have just about got to the limit of what people can listen to for this. And you can see why we're very pleased to be able to bring together this impressive panel tonight. Following the Q&A, we'll close the event and have a small reception. So with that, I'm very pleased to ask Julius to start with his remarks.
Evening all. Just working on the clicker device. Yeah, success. Starting with some trivias, which I thought, frankly, there's a bottle here if anyone can guess all three. So we'll have a bit of an audience call out on this. It does bear resemblance to what we're going to talk about after that. Distance between, who doesn't know my presentation, I quickly add. Distance between Sydney and here.
10,000 miles.
10,000. So hence the tyranny of distance. Commonly used expression, particularly with trying to fly all sorts of transport between Australia and otherwise, but you will see quite a few similarities. Few other historical basics. So 1788, we probably all know. That's when New South Wales was founded as a penal colony, and that's effectively where, for our purposes tonight, you had the adoption of English law. So similar origins so far. And the next question is, Australia contained a nation, but continued to follow, became a nation, continued to follow common law traditions in what particular year? Anyone? There was a 1901. And this is probably the lesser known one. 1986 was the time when Australia's finally abolished the appeal to, I've been corrected on this, the Privy Council rather than the House of Lords. So that was always the route. English law is still persuasive. English common law cases you can still refer to. And here's the key point as far as tonight is concerned. Australian Federal Parliament enacts family law. So, a little bit of history and context, which can go back quite a while. Separate but shared backgrounds for a lot of history. So, divorce can be traced back as far back to Mesopotamian tablets. There are plenty of cuneiform tablets dug up showing that people quite liked to have a good old divorce and bust up back then. Now, arguably, no-fault divorce has some of its earliest and more liberal origins with the Romans, where they believed in divorce, but it was okay not necessarily to notify the other party. Probably a bit distressing when that happened. It probably wouldn't have been very good for all the professionals in the room tonight, as divorce was very much considered to be a private affair. And just a little bit of extra trivia there. Julius Caesar decided that Pompey turning up to political rallies on political rivals' turf was definitely a reason for divorce, and she should be beyond suspicion. So definitely that was a bit more towards the fault-based reasoning for giving you a divorce. As far as our importing divorce here is concerned, Norman Conquest in Britain was brought in the ecclesiastical courts, and most of you will probably know that Henry VIII had a famous little bit of difficulty getting his divorce. So the other point to be aware of, Catholic Church still do not recognise divorce today. So that took a series of separate reforms. As far as England's concerned, 1850, English Royal Commission recommended the establishment of separate divorce courts, and the Matrimonial Causes Act 1857 followed. Grounds for divorce included bigamy, adultery, cruelty and desertion, but husbands were able to claim compensation from the adulterer in that particular matter. So it was not really gender equality at that particular time. Australia generally was still colonies then, or still a colonial system then, and there were statutes whereby they followed English law, but usually the Colonial Office invited the Australian colonies to produce their own law. That resulted in a series of enactments from a series of what we now know as the Australian states. Now, Becky pointed out to me tonight that the first establishment, I thought it was Tasmania in 1860, which I was very pleased to read about, having largely grown up there. But actually, it was where I was born, which was South Australia in 1858, established its own provisions. So up until now, we've got certainly fairly close parallel paths. The big changing point was Federation 1901, 26th of January 1901. Australia created a written constitution, and it's based on both the American and British models. Section 57 gave the Commonwealth, i.e. Federal Parliament, the ability to legislate on marriage and divorce. First significant piece of legislation happened quite a few years later, so they were still using a much old statute, Matrimonial Causes Act 1945, later replaced by the Matrimonial Causes Act 1959, also known as the Burrick Reforms, which allowed divorce after periods of separation. And in the interim, in England and Wales, there are various attempts to reform family law, and actually often overlooked. We largely work under, certain practitioners here work under 1973 Matrimonial Causes Act, but the actual notion of irretrievable breakdown of marriage being the main basis for divorce was introduced, in fact, in 1969. So up to a point, there was some advancement there. So I thought, just in terms of some examples here, and this is really very much from a practitioner's perspective rather than the slightly more academic perspectives that you're about to hear. Historically, there's always been this emphasis on proof and evidence. So distant relative I heard of had to sleep in a dodgy hotel in the 40s, apparently, according to my other distant relative, to separate from a completely insane wife in order to then be able to allow her to petition on the basis of adultery. So that's an example. Private investigators, all of this had to be used. And this will be kind of, if you like, certain practitioners in the room very familiar with, and mediators alike. Clients would often deny or defend, take petitions to heart. It's not ideal. The workaround that tended to happen over here in order to avoid this was the family law protocol introduced by resolution a few years ago, where, well, theoretically anyway, we will have various stories. You show the other side your petition before proceeding to court. You agree particulars so that slightly less offence is caused. But I mean, the real crux here is the last point of my slide, which second last point, sorry, which is in reality an agreed petition to focus away from the client's main concern on child arrangements and finances. And obviously, there's a more obvious point that fault-based petitions tended to encourage hostility and heighten costs over fairly much futile reasoning. So I'll give you an example. This certain heads of my family firm may be familiar with. I had a client who described almost an adultery taking place in the marriage because of particularly first, worst, and last is the usual formulation of how you draft your grounds on the petition. So this one reads, from early on throughout the marriage, the respondent would often leave his dishes in the sink and not clean up after himself, causing the petitioner inconvenience and upset and increasing the strain of the marriage. And this is the almost adultery. On frequent occasions throughout the later stages of marriage, the respondent would frequently go out for what he called wild nights out, drink to excess and attend strip clubs, which offended the petitioner's Christian faith and caused her great distress. And during the evening, I've deliberately dated this before, something I'm just about to come to, which most of you will know in the case, or many of you will know in the case law. And during the evening of 20th January 2010, the petitioner confronted the petitioner about his wild nights out. The respondent told the petitioner to chill out and stop being such a godbotherer. And question, what have you got against funky strip clubs anyway? The respondent then proceeded to regularly go out and increasingly led his life without reference to the petition, causing the petitioner to conclude the marriage was over. That's a fairly standard set of drafting that we were used to drafting up until about a year ago. As a result of the petitioner's behaviour, the petitioner asked the respondent to leave and he moved to a flat in Soho on 30th January 2010. Petitioner suggested marriage guidance and the respondent refused and then said he preferred wild living to puritanical flats, forcing the petitioner to conclude the marriage was unfair. Possible topic for discussion, whether this would necessarily be allowed by certain deputy district judges in the room on the basis of the Owens case, which made petitions like this, which are a little bit on the weaker side of reasonableness, not go through. And the Supreme Court ruled that two parties had to stay married to each other when they didn't particularly like each other. This is what got the changes happening over here. In the interim, in Australia, Australia's Family Law Act, 1975. So yes, certain other Brookmans in the room may have trained for these new reforms that came in. The Labor government, after quite a few years of more conservative policies, promising social changes and divorce and children legislation, this was brought in. It was a well-drafted Act, the 1975 Family Law Act, which was introduced by Senator Lionel Murphy, called in the popular press Murphy's Law, established the Family Court of Australia, and under Section 44, a divorce order could be applied for on a no-fault basis with 12 months of separation. That's how Australia dealt with that. And as we'll find out, popular piece of legislation, divorce rate in Australia continued to rise. It was nearly going to be statistically beyond 50% in Australia since this was introduced, although the statistics have since gone back a bit, I believe and understand. And other than that, obviously people doing very similar stuff in the various state capitals to what we're fairly familiar with doing as practitioners in this neck of the woods. So next bit is how no-fault divorce developed out here. Situation here remained under Section 1 of the Matrimonial Causes Act, one ground for filing a petition, marriage and breaking down irretrievably, various proven facts, with most frequently pleaded being unreasonable behaviour, adultery, provided the petition was brought within 6 months of the adultery, 2 years separation with consent, 5 years separation without consent. So Mrs. Owens had to wait, unfortunately, 45 years, and as did a client of mine in one of my cases, because it was likely the whole petition was going to be defended, and it would have been a very costly exercise, and people didn't want to spend that. So there have been numerous calls for reform. Resolution very much was one believers the charge, senior members of the Judiciary Mediation Council. 1996 was the first attempt to change this with the Family Law Act. Part 2 required parties to attend information meetings, but it was not implemented by the local government, as the then Lord Chancellor, Derry Irvine, believed that it was unworkable. So further attempt was made by Baroness Butler Slot to introduce a private members bill, and that never made any progress until, funnily enough, the wake of Owens, Ministry of Justice commissioned a reform of legal requirements for divorce consultation paper, which the profession responded very favourably to in 2019. Finally, the Divorce and Separation Act, as Saika said, pretty much almost a year ago, came into force as amended Matrimonial Causes Act, removed the bases for divorce, amended Matrimonial Causes Act. So you can now simply petition on the basis of irretrievable breakdown, either jointly or solely, and be interested, show of hands around the room who's generally found that it's a bit easier. So certainly, generally speaking, it's quite popular, spike in petitions, and in practice this has proven quite popular with clients who often concentrate on the bigger disputes, which are children and finances. And just a few follow-up points on that. So Australia actually has somewhat trailblazed on the issue of cohabitants. We'll find out a bit more about that later. De facto relationships, whereas it was slower to introduce same-sex marriage, still regarded as a contentious issue in Australia, that what is traditionally termed as a common law marriage may result in quite a big claim against you. So two partners staying together for a long period of time. And it's also very flexible on financial claims, which is where it gets quite interesting as to timing and when you can bring one. And by contrast, here, same-sex marriage and civil partnerships was included at a much earlier stage. So the Law Commission is reviewing general provisions on cohabitees at the moment, as they are called over here. Just a couple of things to throw about possibly for later discussion. Prior to departure of England and Wales from the EU under Brussels II revised treaty, the first valid proceedings at time would take precedence. So there, David and Rebecca were both, for example, saying that we were sort of hoping for a case example to use on this, where you effectively had a bit of a race. So that was one of the scenarios that could have happened within the 12 months. And the 12 months of separation, could you bring divorce and financial proceedings here, win the race? No longer can happen, no longer happens as much, because the main principle is forum convenience. Although it still does matter, you could still steal a bit of an advantage through potentially filing ahead in one jurisdiction or the other. And because there's still a very different treatment of case law, the division of assets, and because of that, the jurisprudence here, the differences in the jurisprudence here, people will spend money battling it out. And on that note, I would not only hand over to the other speakers, but say, if you see one of these scenarios, obviously go to an international family law specialist. So thank you very much. And with that, I shall.
That's a hard act to follow. I'm afraid my topic is very short on jokes because it's hard on the law. There's not much I can do about it except look forward to the post-seminar drinks. You notice I've used the terminology de facto relationships. That's because in my dual nationality, for the title of my talk, I'm favouring my Australian nationality, but we know that it's called cohabitation here. And as I say, I hate PowerPoint, so I've just done a short paper for you, which you could take home and use as you may think fit, either to light candles or to put in your library. But it's also partly because the law in England on this is extremely complicated, and it's very hard to boil down into PowerPoint, quite apart from the fact that I don't like pressing the button, being of a certain age. Now, I'm asked to do a paper comparing the law on de facto relationships, cohabitation between our two jurisdictions. I could have made it very short, in which case we could have gone straight again into the refreshments and said there is an absolutely yawning gap, more than the 10,000 miles, that's completely different. Don't worry about it, I'll just sit down. But this is the area of family law. I'm not talking, I'm siphoning off child support. I'm talking about the economic relationship between the parties when the relationship breaks down, an unmarried relationship breaks down. There is a yawning gulf between the two jurisdictions in this respect. And that is because of completely different policy perspectives. I mean, the basic policy dilemma, which I've set all this out sort of shortly in my paper, the basic policy dilemma in relation to de facto relationships, cohabitation, is whether you have legal paternalism, whereby you say the role of the law is to sort out family breakdown in a just way, or whether you say, oh no, it's individual autonomy and every person's got the right to choose a particular type of relationship which is differently regulated from other relationships. Now, Australia has taken the legal paternalism, maternalism route, which is, and we've gone very far in Australia. We've virtually, in the area of financial and property effects of relationship breakdown, in Australia, we've virtually equated the law to that applying to marriage. Now, England and Wales couldn't be more different. Australia's done that through bespoke legislative regimes, and I'll explain briefly how they came about. But England and Wales has done an incredibly different thing. There's been great cause for reform, as Julius has helpfully flagged up, over decades, but nothing has happened. So the rights of cohabitants, when they split up here, is governed by the general law. In terms of property, it's property and trusts, and it's equitable doctrines which are not family law specific. And the law is extremely difficult, even for specialist equity practitioners, let alone for us humble family lawyers, let alone for litigants in person, let alone people trying to organise their own affairs. And it's extremely hard. Now, it's difficult really to know whether this position in England, as we have it today, is actually that the country has said we're in favour of individual autonomy, or whether they just haven't done anything, whether it's just a failure to act. I'm not convinced that it's all about a conscious legislative policy. I think it's too hard to touch. I'm too scared of it. I'm going to lose the next election. Well, you're going to lose the next election. And to pick up what Julius has said about the common law marriage, that is a great myth. Unfortunately, loads of people in England and Wales think that they have a common law marriage, they've got the same rights as married couple. Nothing could be farther from the truth. I know from my studies back in the 1970s, which gives my age away, I'm the oldest practicing member in my chambers, but still going. The common law marriage is actually a conflict of laws doctrine, and it refers to a technical concept of a valid marriage where you get married somewhere because there's a civil war or an earthquake or whatever, and compliance with the local form of ceremony is not possible. It's got nothing to do with cohabitation, but it's a widespread myth. And the Parliamentary Select Committee, which reported last year, found that it's still horribly prevalent. It's too late. People break up and they think, I'm the same as a spouse, and they're not. Well, what happened in Australia, even before we had a bespoke statutory regime for de facto relationships, the High Court of Australia got stuck into the law of trusts, and it developed a new form of constructive trust, which wasn't based on the elusive proof of common intention. It invented a constructive trust based on unconscionability, which could be imposed on the parties, irrespective of who intended what. And I've set out 2 cases. And that was a major break. That was before legislative reform. Well, until 2009, the financial relationship between de facto partners, cohabitants, was governed by state and territory laws. And those entities thought that the general law, even though reformed, was no good, so started to enact statutory regimes. And the first pioneering state, I'm afraid, in this respect, was not our favourite South Australia, it was New South Wales. New South Wales started in 1984 with reform limited to property readjustment based on contributions. Generally speaking, the states and territories followed up to the 1990s. Surprisingly, perhaps the most advanced state legislation, you might think, was actually in Queensland, which had a model which was quite like family law adjustment and applied to same-sex partners, and they managed to get it through on Christmas Eve when hardly anyone was in the house. But they went right ahead. Anyway, then people started to say into Australia, I was there for quite a lot of this. What are we going to do about this piecemeal approach that different states and territories have got different laws, they differ in their details, and there were various solutions proposed. There were various fancy Commonwealth constitution powers that could be used, the incidental power and the pendant jurisdiction. I had to learn all this when I went to Australia, but I've never been to a federal system. It's terrifying, but you know, you get on top of it. Anyway, so they thought of, we discussed various things, which included having model legislation, which everybody would adopt. But the radical approach, which is the most sensible approach taken, was that the states, excepting Western Australia, who didn't need to, because they had their own regime, the states referred the power to the Commonwealth. As Julius has said, in the Constitution, as it was originally drafted for 1901, the Commonwealth was given power in the family law field to legislate for marriage and for matrimonial causes, which encompasses divorce and financial remedies ancillary to divorce. And there were loads of debates when I got there in the 70s about what that encompassed. It was a nightmare of case law. But anyway, so the pragmatic solution was taken. Let's refer it all. So a new power over de facto relationships was created. And I've set out in my paper on page 2, I've set out how the Family Law Act 1975, which by the way is now a monstrous statute. I got there in 1975 when it was new and relatively streamlined. Now it's like War and Peace. I mean, it's like Tolstoy's War and Peace. I mean, it's got like, 25,000 sections. It's not for the faint-hearted. But you'll see that I set out the statutory definition, which is basically you're unmarried, you're not family related, and it's a relationship. It's a couple living together on a genuine domestic basis. The Act then goes on to set out factors which can be looked at. Now, one of the reasons why governments in England and in the UK have said we can't touch this is because we can't define it. And okay, the Australian definition has given rise to some case law, but it's not been unworkable. There is, however, a threshold if you want to apply for a financial remedy, as we call it in English terms. There's a gateway or a threshold. The relationship's got to be either 2 years or a child or serious injustice, catch-all, or it's registered. Now, once you get past that threshold, you are treated as if you have exactly the same rights as a separating spouse, a divorcing spouse. And David will tell you in outline what the different principles are in those remedies from between Australia and England and Wales. And the amendments to the Family Law Act to equate de facto relationships with marriage have also given these individuals, these couples, the right to apply for a binding financial agreement in just the same way as a married couple. So once you get over that qualifying period or having a child, basically the financial consequences are the same. Well, let's have a look at England, and I've done a short paper for you because this is extremely difficult law and you'd all be absolutely comatose if I went through it orally or even by PowerPoint. This is extremely difficult stuff. There is no bespoke legislation for property and finances of any sort on the breakdown of habitation other than for children obligations. So you've got your property rights is all governed by the general law. The general law, i.e. the law that our civil law colleagues do. It's not family law. It's not family law. It's general civil law. So for property rights on a breakdown of cohabitation, you've got to look to the general law of property and trusts. As to maintenance, well, there ain't no law of maintenance under the common law. The only way that a separating cohabitee can get maintenance, excuse my sexist language, but in her own right, is if she brings a claim under Schedule 1 to the Children Act, which is only in big money cases, the kind of footballers' fiancés that Julius deals with. And then you apply for what's called a carer's allowance. But as I've set out, it's recently been renamed by Mr. Justice Mostyn and Mr. Justice Cobb. It's now called a Household Expenditure Child Support Award. Okay, carer's allowance was sexist, but that's abomination, but there you are. Now that means if I want to apply for that, I say, Well, in order to support the child of this multi-millionaire in a proper way, I need to have my nails done twice a day, and I need Gucci handbags every week, etc., etc. But I mean, that's nothing to do with ordinary maintenance. There just isn't any maintenance at common law. If you look back historically, and Julius has referred us to the Normans, there was a common law of consortium, which was maintenance, but that was only ever marriage. So, you know, they're out in the cold. So as regards property rights, and I've set this out for you, I don't want to go over it in too much detail, other than to say it's very complicated law. If you want to make a claim to a family home, this has to be dealt with by the Trusts of Land and Appointment of Trustees Act 1996. It comes under the civil procedure rules, both as to pleading and jurisdiction. The family court's got no jurisdiction over this. So family judges like Deputy District Judge Hodson will not get his benign hands on this because there's no jurisdiction. So it has to be brought either in a county court or in the High Court, and it's got to be properly pleaded under the CPR. Now, many family lawyers hate this stuff, understandably, because it's not what we're brought up with. Now, under the general law, if there's an express declaration of trust, that's fine. But often there isn't, either because the property's in one name or because it's in joint names and the people have forgotten to tick the TR1 form, which happens amazingly. And so then you're thrown onto the equitable doctrines, which are saved under the Law of Property Act. And the main doctrines you have are common intention, constructive trust, and proprietary estoppel. And they are both extremely difficult to argue in terms of the legal doctrine, and also they're very evidence-based. And because this is CPR, then loser pays. So this is extremely risky litigation. And because it's so evidence-based, trials take for ages, even for a modest sum. Now, I've set out what the constructive trust is. A constructive trust is basically you've got to show actual intention to share property and then detrimental reliance by the claimant. Now, this has given rise certainly in my lifetime here, since I came back, to a whole load of difficult case law, a lot of it at the highest appellate level. So House of Lords, now Supreme Court, also Privy Council, not to mention the Court of Appeal. And these cases are extremely difficult, and it's just not suited to family breakdown. Why have we still got this general law? And just to illustrate the fact that the case law is very difficult and surprises everyone, not just cohabitants themselves, but their legal advisors. For instance, with the constructive trust doctrine, there was, it's almost axiomatic that you have to show not only sharing intention, but detrimental reliance. That was thought to be completely axiomatic because the maxim is, as civil lawyers tell us, equity will not assist a volunteer. This was thought to be textbook stuff until last year, when we had a case that I put at the bottom of page 4 called Hodson and Hathaway. Now, that was a case where the parties had actually split up in 2013. The case had taken ages to get to court, as these things do. And there was an exchange of emails between the parties about who kept what on breakdown. Emails. And the judge at first instance seemed to say, okay, they'd agreed in these emails as common intention, you don't need to show detriment. So we don't need to show how the woman had acted to her detriment in doing this by paying the mortgage or whatever. It goes up on appeal to a judge in the QBD who says, well, I don't think you need to prove detriment anymore. Then it goes up to the Court of Appeal who say, no, that's wrong. You need detriment. But they said, now this shows you what a shambles this area is. The barristers go into the Court of Appeal on the first day, having argued all this on constructive trust, and the Court of Appeal says to them, why are you arguing constructive trust? Surely these emails are a formal disposition of land in writing, so all this litigation was completely unnecessary. I mean, that is a really classic example. That is terrifying. And, you know, they were very good advocates. One of them is Michael Horton, who is an excellent advocate. And, you know, they get into court and the judge says, hang on, Mr. Horton, why are you arguing constructive trust? But think what this means about the emails, because your clients are going to come to you and say, I've done this email 5 years ago. Oh my God, don't you know that that's a disposition of land that you might... Anyway, that's a good example of how really unsuited this is to family law. Proprietary estoppel is the other main argument, is the other main doctrine. And there you don't need a common intention, you need a representation on which, a representation that you're going to get an interest in land to which the, on which the claimant has acted to their detriment. Now, the doctrine is fairly well established, but in recent years, the case law has focused on fashioning the remedy. Once you've made a once the defendant has made a representation that the claimant's going to have an interest in land, and that claimant has acted on it, what is the remedy? Well, unlike constructive trust, which is purely declaratory, the court can't actually change ownership. But in proprietary estoppel, there's more discretion. You can order a lump sum, you can order license, or sometimes transfer a fee simple. And a classic example of this, which is put out at the bottom of page 5, the wisdom of the Supreme Court in Guest and Guest last October. Now, take down that reference and read it, and good luck. 2022 UKSC 27. For those who have them, it's in 2022, 3 weekly law reports 9/11. Now that's a proprietary estoppel case. It runs to 108 pages plus a 20-page supplement, and the Supreme Court is split 2-3 as to what is the basis of the remedy. Now this might be fantastic if you're the Vinerian Professor of Law at Oxford, but it's not great if you're a family law person advising. Now, I had to write this up for the monthly commentaries I do in family law. I'll tell you, it took me 3 days to understand what the hell it was about. Now, this was about, okay, some of these proprietary estoppel cases, they're not about cohabitants, they're about farming cases where, in the family. Now, in this case, the poor son had worked on the farm for 32 years for low wages, having been told by mum and dad, you're going to get this money, just like, you know, a woman works personally and financially for her cohabitant partner. You're going to get this house. No, I don't. So to vastly oversimplify, the majority in the Supreme Court said the basis of the remedy is a fulfillment of the promise, i.e. you're going to probably get the property itself. Whereas the minority two, why the hell did they bother to do a judgment? Because nobody's going to follow it. They said, no, it's the detriment. Now, we have to wait and see what the effect of this on cohabitation is going to be. It might be more generous. But the sting in the tail of this is they emphasize the width of judicial discretion. They say it's all up to the trial judge. So in this case, it gets remitted back to the Chancery Division to actually fashion the remedy. So having gone all the way up to Supreme Court and 3-2 split, 128 pages, read it, it'll take you a week, it's a nightmare. It goes back. I mean, that is just another example that this is not suited for family law. Cohabitation contracts, I've nearly finished. I told you that under the far-thinking Australian legislation, parties have got the statutory right to make binding cohabitation agreements. Can you do the same in England? Yes, but it's general law, so you've got to fulfill a contract. So you have to have all the elements that we remember from doing contracts when we were at university or not. So you've got to have consideration, intention to create legal relationships. You've got to have formalities if it's land. And that's just beyond most people. It's beyond most people. I mean, it's beyond even lawyers. And unlike Australia, the English courts have never developed the concept of promissory estoppel. Promissory estoppel, which was developed by the High Court of Australia, mainly in commercial cases, is a real help out where a contract is defective as to form. You can look at the promissory estoppel. It's not a promise of an interest in land. So if a bloke says to a woman, I promise to maintain you, but there's no contract. In Australia, that would sound in promissory estoppel, but we've never had that. We've never had that doctrine here. So where are we? Where is England and Wales going? Well, we are extraordinarily hopeless here. Scotland enacted legislation in 2006, and so did Ireland. Not Northern Ireland, but Ireland in 2010. We have just stagnated on this. The Law Commission made quite a modest but a useful proposal in 2007, which recommended a statutory scheme based on only related to property, but based on financial and non-financial contributions, an adjusted regime, unfortunately not taking account of future needs, so much more limited than the Australian pattern. Now, this came to that. The House of Commons had a look at this. The House of Commons has a Women and Equalities Committee, and they did quite a good report last year, which was issued in August, issued in July, published in August. And they said, like I have, the general law is absolutely hopeless. It's costly, complicated, and unfair. And they said to the government, enact the Law Commission's proposals from 2007 and do it by next year. Well, within a couple of months, the government said no. Why did they say no? Well, David will take up on this. They said we can't possibly look at cohabitants because the Law Commission's going to have a thorough look at financial remedies for divorcing spouses under the Matrimonial Causes Act, which hasn't been reformed since 1984. And so we'll look at that before we can look at de facto relationships. Now that is going to take ages. I mean, I'm afraid, I think both David and Julius, possibly, certainly me, will certainly be long past practice before this happens, because the Law Commission said on the 3rd of April that they are going to look at the rights of divorcing spouses, and they promised to do a scoping paper, which is kind of where do we go, by July next year. So poor old cohabitants are going to be out in the cold for ages. And, you know, I'm not convinced that it is because the government, the legislature said, oh no, it's all about individualism. They've just done nothing. And we're left with this absolute mess of the common law. And it is really tough stuff. And I think policy issues, they're controversial, but they should be confronted, debated, and a democratic decision done, not to leave this awful default situation we've got. I mean, it is a nightmare advising cohabitants, and it's not just legal practitioners, it's a nightmare for mediators, because people, how can they know their rights? You're going to tell a cohabitant to read Guest and Guest, 120 pages, with a reference to every equity article written for the last 40 years. Well, come off with it. Anyway, so I think England and Wales has been absolutely hopeless, and I'm proud to be an Australian.
Thank you very much indeed. Good evening to you all. I'd like to step back and perhaps look at world trends over the last 20, 25 years. And surely one of the geopolitical trends must be globalism, putting Trump to one side, very much putting Trump to one side. Surely that is what has been happening in our world, and many of us hope it will happen, continue to happen. And those of us here doing any form of work with international clients, Anglo-Australian clients, have had the marvelous opportunity over these past couple of decades of being witnesses to what has been the globalism of our planet. We've seen whether it's multinational companies, employers, employees, trademark disputes, or for some of us, international families, how much there has been a coming together of many countries. And England and Australia probably has a longer history than any of the other countries, perhaps apart from within Europe for obvious reasons. Well, we've borrowed and we've shared whatever our laws are, whatever we think of policies, and this is why this is an interesting evening, because we've looked at their divorce, we've looked at de facto and say, why are we different there and why are we similar? Many of us must hope that we're going to have a narrowing of this, that we are going to have a greater coming together for those in their mid-career, looking hopefully over the next 10, 15 years of a coming together of nations for the sake of those who are caught in the middle, and for those of us doing family law, that is international families. Because what is the alternative? The alternative is, sadly, we each go into our own little burrows and say, this is my law, and this is my law, and this is my law. And the victims of that, let's be frank, are international families and their children, for those of us in the family law context. So perhaps apart from Australia and New Zealand within the European Union, surely Australia and England and Wales must be the obvious answer to look at how has it worked, how could it work, what is the model for the future, especially as we are a common law jurisdiction, especially as there are significant differences with civil law. So what are some of the similarities that we have here? That's if I point in the right direction. That's how it works. Good old-fashioned press the button. What are some of the similarities? Well, first of all, our two jurisdictions try and find a fair outcome. Quoting Pilot, what's the truth? What is fairness? But I think we probably understand in each of the two countries what that fairness probably means. Equality of genders, obviously, but not obviously in a number of countries. No discrimination, sexual orientation, ethnicity of faith. Again, we come up against this quite often. Best interest of the children. Our countries have embraced the 1980, the 1996 Hague Conventions, and we're working in the same direction. We apply local law. Again, one of the bigger differences with the civil law jurisdictions is the application of foreign law. We are classically common law countries. Compare New Zealand, that's got a lot of codified elements that one might say, certainly in the family law tradition. And we've got shared case law. We're always swapping cases. I've been consulted by Australian lawyers who say, well, I'm taking a case to appeal. What's your law on this? And I suspect Becky have also been contacted on a similar basis. So we're giving help to Australia. Australia is giving help to us. It'll be surprising now to have a major case, I suspect cohabitation case you mentioned, without looking at what's going on in countries like Australia. So we're sharing very substantially. And we're borrowing from each other's statute laws. Mostly we borrow from Australia, they don't borrow much from us. There's an interesting element there. So I'm asking the question, why is it that there are some differences? Well, what are they? Well, one of them, I think Becky's already referred to, is the coyness of our Parliament in England to legislate in family law matters. Australia in the 1980s and onwards has gone straight in and said, well, we'll do this and this and this. And we won't. Why is that? That's got to be a political element between the two different countries. What could we learn? And a number of you here are lawyers in other areas apart from family law doing Anglo-Australian work. So the whole point of the Anglo-Australian Law Society does such a good job bringing lawyers together. What can we learn from family law that actually overflows in other ways? What can we learn from Australia to improve our own English law continually? And are the differences increasing or are they narrowing? And why is that there? And then can the similarities blur the differences? When I went to work Sydney 20 years ago, I found the differences beguilingly similar. It was quite difficult in some ways to actually say, well, that looks similar, but actually it's quite different. How is it? So I want to cover just a few topics just in summary to say where have we got similarities and where have we got differences. Each time saying, why is that? Why might that happen again? And what can we learn from that? Set out the issues as I want to go through them one by one. And the first one is ADR, Alternative Dispute Resolution. Conscious a number of mediators are here. I'm a mediator myself. Well, in England, mediation came from the USA and Canada, family mediation, but it also derived from the therapeutic professions. And so we find some elements of English mediation very similar to the therapeutic professions. We have 90-minute sessions. Okay, we're getting rid of it. But traditionally, it was exactly the same as the therapeutic profession. We have a sort of strong element of supervision, of finding common ground. And yet it's quite interesting that that's quite different in some ways the Australian model. We've looked at the passive approach. We've looked at finding common ground. We've helped to renew the dialogue. And that will be very easy to understand for a therapist. And where's it come from the lawyer? Australia, particularly from the 1980 changes onwards, we've already looked at, found it much closer to the court experience. It was less, let's go off into a therapeutic type environment to see how we can work out some differences there, learn to parent better. This is a dispute, we're going to sort it out outside of court. Strong Australian feature there. We're going to sort it outside the court process, but in some ways alongside the court process. And so the focus was not on the therapeutic element, it was on the resolution of dispute. And so Australia over the 80s and 90s and onwards had a much more directive style of mediation. And certainly I know when I went over there 20 years or so ago, it was a style of mediation that was very, very different to what we had and what we were using here in England. And what happened? Well, about 20 years ago, we adopted the Australian model. And now you'll still find the passive neutral mediation that goes on as was traditional in England, but we've now adopted the Australian model, partly by using the terms of agreement in Australia, to be directive, and is primarily in the financial realm, and is primarily from lawyer mediators who are doing it. So we've learned an awful lot. So we've learned an awful lot, and we've borrowed from what has happened in Australia. And then we came to arbitration. And arbitration came in Australia in 1991. And so we said, well, this is a good, I was involved in bringing it into this country, really, really good, very, very helpful. We could do with our arbitration in England. And mediation was not going anywhere very fast, and it was causing problems, etc. And we looked across to Australia, and Australia said, oh, we've had it since 1990, although the rules came in much later. And it didn't really take off. And why was that? And what was the difference between two very similar countries, very similar ethos of lawyers and practitioners, etc.? We launched in England 2012. It's a non-statutory scheme, family arbitration scheme. And the rules were explicitly Australian. I know, because I went to the Law Society of New South Wales and said, can I have your rules of arbitration? Thanks very much. It was simply a Word document, put it across to England. We tinkered with it, but by and large, you'll still see words that are actually word for word, the same as the original New South Wales model. And so it was there. But we then said to ourselves, but why isn't Australia doing more arbitration? And this is where we looked back, and we spoke to many Australian lawyers. We said, well, before we go much further in England with arbitration, why isn't it taking off in Australia? And what was interesting is because Australia had a directive mediation model, there wasn't the need so much for arbitration, because the lawyer mediators were actually encouraging the parties, they were steering the parties. We had a more passive version, where it was a more open discussion. And that generally is the view as to why we changed it. And so what we now see is that different forms of mediation have therefore led to different forms of ADR. Arbitration is now taking off more in Australia, mainly because the court service is so slow. The court cases are really slowed down, particularly in places like Sydney. And what's the other form of ADR? A neutral evaluation. And that's a big issue within England, particularly in London, where we have an in-court process where the judge gives an indication of what's the likely outcome. Financial dispute resolution hearing. And one of the big successes in London has been the private FDR. And I've spoken to a number of Australian lawyers in Sydney and Brisbane and elsewhere, saying, why not bring it in there? We could bring it as a private model. So will we see actually something like that go there? The next element is children and finance. In Australia, the proceedings will be started together and they will be heard together. Years and years ago, England separated them out. They had no similarity. And so now in England, you will get different courts dealing with children matters, different lawyers. In my firm, we've got a few lawyers who do exclusively international children, and a number of us do exclusively international divorce and finance. Different statements, different laws, and ways of working, tables. And what was the reason we separated out? There was this idea of bartering. Well, I'll give you the house if you give me the children, etc. And that was generally not perceived as in the best interest of the children, etc. And so we separated them out. We're unlikely to change that. But equally, Australian lawyers I've spoken to have got no intention of separating it out. So we can each see our own ways of doing it. And so should we separate it? Well, simply no, it's working, it's working. But should there be some coming together in that? It seems to me that in England, we need at times to bring finance and children together. One of the big areas of work is relocation cases. Somebody is happily in England, they separate, divorce, and one of them wants to go back home to Australia and take the children, a relocation case. And certainly when I've been sitting, I've had a number of cases where I've had to sort the finances out after it's been agreed that one party, normally the mother, will relocate to Australia. And they say, oh, well, I'm going to relocate here, I'll have this much money, etc. And then they get to the finances and say, well, actually, no, we're not going to have this much money. The outcome is going to be quite different. And I think that England should now be saying to itself, I wonder if the time has come for some of our children and finance cases to be combined together instead of separated out in that particular way. What's it going to happen in that regard? Next heading is rather a controversial. What's a woman worth? Well, in the case of White, sorry, the brickbat's thrown. In the case of White, the starting point was found to be equality, gender, spousal equality. There's no need to show equal contribution. It's deemed equal contribution. Many discussions have taken place at senior level, government, judicial, lawyers, to saying to us, well, why don't you bring something in? And as I understand it, it is still not in statute law, and it is still not in case law. Australia is still strongly wedded to contribution. This contribution, that contribution, showing the contribution. And that's now very rare in England for White. But in practice, and this is where I find it interesting, even though we've got quite a significant difference there, in practice, in many cases, the outcome would be fairly similar to equality, or you look at needs, etc. And so here we have a situation where statute law is quite different, case law is quite different, but because the practitioners would by and large say, well, of course, we've got to start with some sort of equality. We don't have it in statute law, we have a case law, and we get to that similar point. An interesting element there. Another interesting element is marital agreements. I've actually spoken about de facto agreements. Australia had binding marital agreements since 2001. Australia has probably been the strongest country anywhere in the world in requiring preconditions to a marital agreement. And that was in 2001. As the years gone by, Australia's government has said, well, actually, that's too strong. We'll slightly pull back. But still, Australia would be the strongest country in the world in having preconditions before a marital agreement would be upheld. In contrast, we have no statute law, absolutely none. We have a case called Radmacher, persuasively binding, opportunity of legal advice, disclosure and meeting needs. And yet, both countries would say we've got exactly the same intent. Our intent is protecting the vulnerable party at the time of entering into these agreements. There's a huge gender element behind some of these aspects, protecting perhaps the woman as the more vulnerable party. And so we've got two countries absolutely focused on protecting the vulnerable party entering into a marital agreement, doing it in two completely different ways. Interesting, to contrast with the civil law system, they have no separate representation done before a notary, etc. And for them, the importance is certainty. Not necessarily the English-Australian approach of saying protecting the vulnerable, but it's the absolute certainty. And it seems to me, going forward, that globalism, one of the biggest issues we've got to deal with is how do we look at international marital agreements, particularly coming out Europe. How do we weigh them up? How does England, Australia, New York, other countries like that deal with it? Forum, Julius has already touched on that. Many international families, England, Australia most classically, have connections with two or more countries. Where should the proceedings be? And those of us here in this room who are family lawyers to the international world, it's the big topic. It's the first thing we deal with. Where's the forum? It's the big issue for us as specialist lawyers. Post-Brexit, we have to mention Brexit once, haven't we? Post-Brexit, England has an entire discretionary approach. In law, it's convenient, balance of convenience. In case law, it's closest connection. Australia is very, very different. Australia will accept proceedings provided Australia is not a clearly inappropriate forum. Case of Henry, I acted for Mr. Henry in England, and it was a German, Monaco, I think a Swiss, English case, and there was a remote Australian connection in some ways. And that case was won all the way up to the top and lost on appeal. When it was said, it's the clearly inappropriate test. Well, you'll see that self-serving is, I would say, very biased. It means you're more likely than not to have it within Australia. Malaysia is another case that has got this, and we had a leading case about 5 years or so ago. I find it interesting that when Australia and New Zealand entered into, I think there's the Trans-Tasman Agreement about 5-7 years or so ago, they adopted another forum test. And I spoke to a number of judges informally. They said, well, why don't you try and push for it to be generally? I find that a very partial, self-serving element, and it gives rise to the risk of parallel proceedings. Because England says, we are the closest connection. Australia says, well, we may not be the closest connection, but we are not clearly inappropriate for them. So both those are full steam ahead. What's the incidental problem with that? The incidental problem is that Australia requires 12 months separation. So Becky and I have had a number of cases. We're still trying to find, I think Julius mentioned, still trying to find the big test case that we can take. Australia needs a 12-month separation. We say, oh, yippee. Even under the court-based law, we could issue whenever we wanted, etc., no period of separation. So we issued in England full steam ahead, etc., and sometimes under the no case, they respond no till much later. So we gained an advantage. But Australia has got freestanding financial claims, which we don't. And so Australia would be going full steam ahead with the financial claims. So you had this odd situation. England was progressing the divorce. Australia couldn't progress the divorce, waiting for the 12-month separation. It was progressing the finances. How should that be resolved? Well, we've been looking for this for a long time. We had one a few years ago where we thought, oh, yippee, we could get this decided, and then unfortunately settled. But so a real, I think that in years to come, I've got no political insight into Australia. I think Australia will ease back on that and will probably accept the more conventional closest connection. And the last one is a more sort of instinctive reaction of how different it is to practice, and we've practice in two jurisdictions. The first one is, how do we go for disclosure? And this is again an interesting one. People are astounded that in England we have self-corroborated disclosure. We have people giving their own answers to questionnaires and financial disclosure. And particularly in Australia, but many Australians, they simply cannot understand how we can ever do that, because so much of that is externally corroborated through subpoenas. It's a major part of the paralegal assistant solicitors' role there. And yet we are very rarely going to have third-party audits. I can't remember. Oh, it's a long time since we've had orders of banks and things like that to try and find it. Very, very rare. But we both think it works well. And by and large, it does. We are two countries who are, by and large, with a very good reputation for getting to the heart of the finances. And yet we do it in very different ways. Hearsay, last thing to say is hearsay. I can't remember sort of maybe a case of hearsay recently. I simply can't remember a case involving hearsay. And yet I know within the first week of being in the office in Sydney, I was shown a double volume textbook on evidence, and hearsay is crucially important. And how can we have two so similar jurisdictions with presumably starting from a common root of the law of evidence? And so we've moved so far away in the family courts. I've said optimistically any conclusion. The answer is I'm not going to give any conclusion. That's the point of a question and answer session, and that's the point of having a dialogue between ourselves. Thank you very much indeed. Can I thank you for organising? It really is an interesting issue of trying to know why are we so similar, why are we different, and where have we moved apart and why? And if we are going to be a model for the world, and I stand back to the globalism, if we are going to be a model for the world, what can we actually do to come together and say, well, we're doing something different, but actually it's seriously worth it. And over to you, thank you very much indeed on behalf of the Anglo-Australian Lawyers Society for arranging this.
Thank you, David. It's now time for questions, if anyone's got any. Did I see your hand go up there?
Yeah, yeah.
And what's your question?
We haven't talked very much about children, but I promised.
Would you mind standing up so we can all hear you? Thank you.
We haven't talked very much about children, but I promised that I would ask this question on Prof. She is a teacher who wants to emigrate to Australia, and this teacher has the benefit of special guardianship order in respect of a 3-year-old girl. This client believes that the only way she can go to Australia with this girl is if she adopts her. Is that correct? Or is that correct?
Got our public issue to respond.
There's a reason you can include children. It's only Becky and I, maybe Julius as well, don't touch children for social services. And we must have good news. I think the answer is no. Even though there's a special guardianship order, I'm looking at three of my colleagues here, even a special guardianship order, it would still have to be a relocation application. Both natural parents would still have, I believe, rights of custody, as technically referred to in the convention, and they would have to apply for a relocation application. I think an adoption order would, one, take an awful lot of time, secondly, an awful lot of money. I think this is a red herring. My personal view would be a red herring because it's not dealing with a real issue. And if it came to light that the only reason for the adoption was to actually subvert the relocation application, I think it would be stopped. Relocations are not easy, but we have changed a lot. We had a piece called Pain and Pain, which really put the scuppers on it. But that was a important appeal on the right and read that about 10 years or so ago. And by and large, there is a pretty level playing field there for relocation. There are many successful relocations between England and Australia.
David's right. I mean, the issue in relocation cases, whether they're, you know, I want to take the child from Penzance to Berwick-on-Tweed, or whether I want to take the child from London to Auckland. The issue is whether it's in the child's interest. It's not the question of the status. You know, somebody's got parental responsibility, but that's the platform. That's not determinative. I mean, if you have sole parental responsibility, you know, if you're a mother and there's no father ever been around, or if you have parental responsibility in a marriage or by adoption or by special guardianship, that's just the basis on which the welfare evaluation is made. It's not a matter, because otherwise you'd be treating the child like a commodity. You'd say, you know, I've got parental responsibility, whether through this, that, or the other. I'm just going. And that's not the way it all works. I mean, this case is extremely difficult to adjudicate, and you know, the further the proposed relocation, the worse it is. You know, I mean, if you want to relocate from Dover to Calais, you know, absent the queues like they were over the weekend before Easter, it's not bad. But I mean, if you want to go to New Zealand, it's really heartbreaking. But it's not determined by which form you get parental responsibility. I think you start off on a level playing field.
I agree. As well.
Yes,
Online, do that. See if anyone gets a hand online.
Yes. I have a question. It's picking up on the individualism. Do you have that option in Australia in the way that you do in England when it comes to cohabitation, for example? What if you want to opt out? Yeah.
Well, you have to do it. I mean, it's not,
You might not
I mean,
want to
in England, what's been discussed when we got round to thinking about a statutory scheme, people have talked about should you have an opt-in model or an opt-out model. Now, the problem with an opt-in model is that you fall into the same trap of people not knowing their legal rights, so they don't know what the hell they're opting into. Whereas with an opt-out, at least you've got, you've got an umbrella of protection. I mean, I know in Australia this was controversial, and one of the old chestnuts that's wheeled out in England and Wales is, you're undermining the institution of marriage and whatever. But I mean, when you think of Australia, which has a large Catholic population and a large Greek Orthodox population, there are lots of, there are very strong Christian values, and the sky didn't fall when the de facto relationships legislation was, God didn't come in his wrath and destroy the country. So, but I think to answer the legal question, I think there's no structure for opt-out save by a binding financial agreement. You don't opt out of the whole scheme. You don't say, I'm not touching that statute. You would say, well, I know that I'm covered by this, but I'm going to modify the court's discretionary powers as to maintenance and property adjustment by saying this is the binding agreement. And the binding agreement is much more binding there than the Radmacher agreement here. So I think that's the avenue by which you do it. Do you agree?
Yeah. I mean, I think this is part of the problem. What model of law reform do you adopt? Would you adopt, as Becky said, the Australian model, which is by and large reciprocate similar to marriage? Or would you go along the Law Commission route of about 10, 15 years ago when they came out with a report of a sort of equitable entitlement or disadvantage? Or would you have a model which didn't require people to opt in or opt out? If they're going to opt out, they've got to have the entitlement of legal advice. And the thought for government is bringing in a law for everyone in the country who's in a cohabitation relationship to say, well, by the way, you've got to go and see a lawyer to actually agree to opt out, is where they came stuck. As I understand it, they got stuck. And said, we're simply not going to produce a law that requires a significant part of the population to regularly go off and see people like us. And so they switched it around and said, well, therefore, it's going to be the different version. But again, how much do you allow people to enter into these agreements without having legal advice? And that, I think, is the problem, is finding the model.
Yes. Do you have any more questions?
Yes, they are. There's going to be an exam next.
So we do have large volumes of Prosecco, and we're here till the at the end. So to enjoy.
We can have an informal
Any
discussion.
Okay.
Any online questions? You guys can ask questions online as well. I don't see any hands up though.
Okay, so if there are no questions, I'll just finish off then. Okay, so I'd like to bring this presentation to a close by thanking our speakers for their fascinating insight into family law and how that's conducted differently in Australia. Julius Brookman, together with Caroline Ford, some in this room as well, are our newest additions to our family law team here at Branch Austin McCormick, a rapidly expanding family law team. And it's great to have you on board. Julius, thank you for that comparison of no-fault divorces in the different jurisdictions. It seems bizarre that just over a year ago, we're still advising our clients that if they wanted to get divorced, they needed to demonstrate that their spouse had behaved badly or had gone off and had an affair. Professor Rebecca Bailey Harris, thank you for bringing home to us just how much catching up we have to do on the law of cohabitation. The family lawyers in this room will know that our cohabiting couples routinely assume that they have the same rights as married couples, and I'm quite shocked to discover that actually they haven't. They have no recourse to family law. Professor David Hodson, I think it's fair to say that I've always been slightly bored of your accomplishments. So it's been a great privilege to hear you speak. and the differences in our approach to family law in the different jurisdictions, particularly when it comes to how we deal with the separation of financial matters and divorce in England and Wales. It comes as a bit of a revelation to discover that in Australia, they deal with both matters together. Last but not least, I'm Bodley. Thanks so much for all the time you've taken in pulling this presentation together, in introducing our speakers, and ensuring that it has all gone to plan. We have, as a token of our appreciation, my glamorous assistant, Julius, is going to. Thanks so much.
Yes, food, drinks, yes, suitably Australian. I don't think anyone actually necessarily won the won this. I think Anne got enough answers. So that's also for.
Okay, so that's are we done? Yeah. That brings our family law presentation to an end. Thanks once again. Please enjoy the snacks and refreshments. We're all available to speak to you should you have any further questions. Thank you.
Thank you for those. We're disconnecting you now.